The marble courtroom dropped silent as Judge Anthony Terenga's gavel came down with unprecedented force. He blushed with rage. He glared downward at Congresswoman Jasmine Crockett, who stood quietly at the defense table. Isaberi. Isa Peter Seni Shafans intensen. Istuberi intensen. Miss Crockett, your remarks regarding this court's procedures amount to direct contempt, he declared, his voice strained with pent-up anger. I am directing the bailiff to arrest you forthwith. Gasps filled the crowded federal courtroom. Onlookers stared in stunned silence as the bailiff moved toward the composed Congresswoman, handcuffs in hand. Camera phones were raised all over the gallery, snapping the unprecedented instant when a federal judge tried to imprison a sitting Congress member during a star-studded hearing on voting rights. What transpired over the next 5 minutes stunned every person in attendance. Judge Terenga's face would contort from indignation to stunned awareness as Congresswoman Crockett coolly presented evidence that not only exonerated her stand, but embarrassed the judge's melodramatic overreach. Evidence that would immediately go viral and rock the foundation of the federal judiciary. Before we go deeper into this great courtroom showdown, take a minute to like this video, subscribe to our channel for additional tales of powerful people fighting for justice in the face of overwhelming odds. Now let's get back to that morning. The Federal District Court of Northern Texas. The United States District Court for the Northern of Texas courtroom was already charged. Started that morning. Case number 23, 4701, Coalition for Voter Access v. State of Texas, had gained national at important recent voting rights challenge. Opposite them sat the state attorneys, headed by Deputy Attorney General Maxwell Reed, a Harvard-trained attorney of 20 years defending state policy. His team took over their table with the air of assuredness, individual power and state behind them. On the other side of the aisle, the plaintiffs' table, a group of civil rights groups that were suing Texas voting SB 4790, headlining their legal none other than Congresswoman Jasmine Crockett, who had temporarily taken time off from legislation to argue the coalition pro bono. Prior to her election to Congress, Crockett had established a reputation as a civil rights lawyer with several landmark significance under her belt. Presiding over this explosive case was Judge Anthony, a veteran jurist, courtroom management conservative interpretations of the law. Installed on the federal bench 50 before, Terenga had built a reputation as a jurist who accorded great deference to state legislation matters. His growing short temper with voting rights plaintiffs in recent notice observer. The tension in the courtroom was not only the high-stakes nature of the case, but also Judge Terenga had restricted that Crockett had out loud referred to abnormal judicial. The words spoken to the press reporters at lunch with the judges by more. Before we proceed with Judge Terenga started at the hearing, his tone laced and lawyers. I would like to see statements made to media yesterday regarding procedural rulings court. Crockett rose from her seat, standing firm even in the face of the judge's tone. She was 42 years old but held herself like a person to high-stakes showdown. Your Honor, if you are speaking of my comment, I maintain my professional judgment yesterday. The judges narrowed their eyes. Miss Crockett, you indicated to this court that it was being biased. Those kinds of allegations do vitiate the integrity. If I may say so, respectfully, Your Honor, Crockett responded. I said that excluding testimony from impacted voters but permitting lengthy testimony presents appearance of imbalance. That is a factual observation regarding the effect of the court's ruling, not an allegation of prejudice. Deputy A.G. Reed jumped in to object. Your Honor, let's go ahead with today's witness instead of focus on press release. But Judge Terenga was not willing to drop the issue. Miss Crockett, you're not only an attorney in this case, you're a sitting Congress. Your words have import and implications outside of this courtroom. All the more reason I must be truthful about issues of voting rights, Your Honor, Crockett replied. My dual obligations court constituents on matters of democratic access. The gallery buzzed and mounted. Reporters took hasty notes, sensing the impending confrontation between two giant egos, a federal judge who takes pride in unchallenged authority in his courtroom, and a congresswoman renowned for her unyielding advocacy. Let me be explicit, Terenga began, leaning forward. This court will not be swayed by political agendas or the news cycle. The laws of evidence and procedure apply to all parties equally irrespective of political affiliation. Crockett nodded. I couldn't concur more, Your Honor, and that's why I've drafted a motion regarding the disparate implementation of those very rules during yesterday's hearing. She picked up a document from her desk. Our motion illustrates how the court granted state witnesses unlimited time to debate hypothetical voter fraud situations with no evidentiary basis, while limiting testimony from voters themselves who had documented proof of disenfranchisement. Judge Terenga's expression grew dark. Ms. Crockett, filing a motion does not give you a right to lecture this court on procedure. I'm not lecturing, Your Honor. I'm representing my clients as is my ethical duty, Crockett retorted. And I've cited particular cases where the limitations of this court appear to conflict with settled precedent in the Fifth Circuit. The judge's patience visibly wore thin. The Fifth Circuit has uniformly accorded district courts wide discretion on evidentiary issues, with certain restrictions that I think were surpassed yesterday, Crockett continued, opening a legal encyclopedia. In Garza v. Texas Department of Elections, the Fifth Circuit specifically ruled that sufficient. Terenga cut in, his voice escalating. Ms. Crockett, your repeated defiance of this court's jurisdiction approaches contemptuous behavior. Crockett kept her calm. Respectfully quoting applicable precedent is not contempt, Your Honor, it's zealous advocacy, which is my ethical duty under the Texas Bar Rules of Professional Conduct. The audience could sense the judge's ire mounting like a brewing storm. Few lawyers would risk continuing to push an argument after a federal judge had made so obvious a display of irritation. But Congresswoman Crockett remained unruffled as she pressed on with her careful legal case. And in addition, Your Honor, the recent Supreme Court ruling in Democratic National Committee versus Wisconsin State Legislature underscored that courts need to accord particular attention to direct testimony of disenfranchisement of voters. Exactly the testimony you curtailed yesterday. It was this observation that appeared to send Judge Terenga over the edge. His face reddened as he interrupted her in mid-sentence. Ms. Crockett, I hold your continuing interference with this court's authority, as expressed in the press and now in the open courtroom, to be direct contempt. I am directing the bailiff to take you into custody until such time as you're prepared to demonstrate proper respect for these proceedings. The bailiff moved forward, handcuffs in hand, as stunned whispers spread through the courtroom. Crockett remained motionless, her face impassive as the judge's extraordinary order lingered in the stunned atmosphere of the federal courtroom. As the bailiff moved toward Congresswoman Crockett in handcuffs, the tension in the courtroom approached a breaking point. A handful of members of her defense team leapt to their feet in outrage. Her chief co-counsel, Jennifer Washington, immediately spoke up. Your Honor, we respectfully object to this contempt order and seek an immediate stay pending emergence. Appeal to the Fifth Circuit, Washington asserted firmly, already picking up her phone. We also remind the court that Congresswoman Crockett has certain immunities as a sitting member of Congress. Deputy A.G. Reed, clearly uneasy with the threatening situation, also stood. Your Honor, although the state clearly has no position on the issue of contempt, maybe a short recess would be in order before such a drastic measure is taken. Judge Terenga's face stiffened. The congressional privilege to which Ms. Washington refers is applicable to speech on the floor of the House, not to contemptuous conduct in my courtroom. The contempt order remained. During this exchange, Crockett was very cool. When the bailiff approached her table, she held up her hand a little. One moment, please, she told the bailiff in a quiet command. Then addressing Judge Terenga, Your Honor, before you resort to jailing a member of Congress for invoking legal precedent, I think judicial ethics mandate that you disclose certain facts to all concerned. The judge's brows furrowed. Ms. Crockett, you have no authority to lecture this court on judicial ethics. I'm not lecturing, Your Honor, I'm presenting relevant facts, Crockett said, opening a folder on her desk. Yesterday, while working on case documentation, my team uncovered something troubling that is directly relevant to these proceedings. This is not the moment for new evidentiary issues. Terenga snapped. The bailiff will continue. Crockett remained calm even as the bailiff edged nearer. Your Honor, Canon 3 of the Code of Conduct for United States Judges mandates disclosure of personal relationships that may lead to concerns regarding impartiality. I found communications showing you have undisclosed relationships with individuals who have direct financial stakes in this matter. An oppressive silence descended upon the courtroom. Judge Terenga's face showed real surprise, then dismay. What was it, Congresswoman? He demanded, his voice now wary. I'm not suggesting anything, Your Honor. I'm reciting facts, Crockett replied, pulling a document from her file. This is a chain of emails exchanged between Your Honor and Richard Fulton, president of Secure Vote Systems, the company that landed a $43 million contract to install voting restrictions, which we are opposing in this case. Murukshires buzzed around the courtroom. Journalists craned forward in their chairs. Those messages would be privileged and immaterial. Tonga replied, albeit onlookers said his conviction appeared to falter. Usually, maybe, Crockett agreed. But those messages were on public servers because they were being sent to and from your official court email address, which makes them open to Freedom of Information Act requests. Of greater significance, though, they demonstrate you and Mr. Fulton presenting this particular legislation months prior, and it being introduced publicly, with Mr. Fulton thanking you for your advice, of course, on how to write regulations that would pass judicial scrutiny. The gallery burst out in shocked, gasping whisper. Judge Terenga pounded his gavel repeatedly. This is outrageous. Those emails are being completely taken out of context, he maintained, his initial calm patently breached. The emails are very specific within their context, Your Honor. Crockett pressed on resolutely. They also indicate that you had 3 private dinners with Mr. Fulton during the time while this legislation was in preparation. None of these contacts were made known to the parties in this case, although Secure Vote's clear financial stake in the outcome was manifest. Deputy AG Reed rose again, his face visibly uncomfortable. Your Honor, the state was unaware of these purported communications. If they do exist as characterized, they clearly would be pertinent to possible recusal issues. Judge Terenga's face had turned white. These are procedurally improper and potentially libelous charges, Congresswoman. They are improper and libelous only if they are false, Your Honor, Crockett responded. And we have verified these communications through the proper legal means. She displayed a second document. This is a court certification from the IT administrator verifying the authenticity of these email correspondence in accordance with a valid FOIA request. The bailiff, who had been hovering uncomfortably around Crockett during this confrontation, glared at him for instruction, visibly unclear about what to do next. Crockett took advantage of the situation. Your Honor, I have with me a motion for your instant recusal on the basis of these secret ex parte communications and conflict of interest. I've also drawn up an emergency petition to the Fifth Circuit in case you refuse to recuse. She paused, then continued. In addition, I am duty-bound to report to the court that copies of these communications have already been sent to the Judicial Conduct Committee and the House Judiciary Committee on which I serve. Judge Tonga's face went through a gamut of feeling, anger, concern, and eventually a realization of his exposed position. The court was heavy with tension, all eyes upon the judge. In addition, Crockett went on to say, these same unstated communications would render any order of contempt against counsel, who was rightfully questioning the court's impartiality, look retaliatory instead of remedial, something the Fifth Circuit has been especially sensitive to in recent years. She put the papers back in her folder intentionally. Under these conditions, Your Honor, I respectfully move that we postpone both today's proceeding and the issue of contempt until we may address the issue of recusal as judicial ethical guidelines dictate. The courtroom was in stunned silence as Judge Terenga struggled visibly to take back the proceedings. The bailiff remained uncertainly at Crockett's side, handcuffs now dropped to his hip. Judge Terenga finally cleared his throat after what felt like eternity. Given these shocking revelations, this court will adjourn for a 30-minute recess to consider the materials cited by counsel. His voice lacked its previous authoritative tone, instead becoming strained formalism. The bailiff will withdraw. We are in recess. As he stood up and hastily departed to his chambers, the courtroom erupted into chaotic whisper. Journalists scrambled out to write updates while legal observers shared stunned commentary on what just occurred. At the plaintiff's table, Congresswoman Crockett seemed unruffled, quietly advising her legal team. The handcuffs that had nearly been placed on her wrists just moments earlier now seemed like a distant threat, replaced by the much more serious implications of the documents she had dramatically revealed. When Judge Terenga returned to the bench after the 30-minute recess, the transformation was remarkable. Gone was the commanding presence that had dominated the courtroom just an hour earlier. Rather, He approached with the slow deliberation of a man traversing a minefield, his face wary as he smoothed his robes and looked about the crowded gallery. The courtroom was hushed as he cleared his throat. Prior to discussing the issues raised by Congresswoman Crockett, I would like to establish some facts for the record, he said, in a voice considerably more measured than he had hitherto used. The communications mentioned do happen, but they need to be correctly placed in context. He hesitated, as if he was selecting his next words with great caution. Although I did have email exchanges with Mr. Fulton and participated in a number of events where he also featured, our interactions were mostly within the context of a judicial conference on election law, where we both served as speakers. Congresswoman Crockett said nothing, her face immobile while she listened. But Judge Terenga went on, reviewing during this recess, I must admit that some parts of these communications might give the appearance of impropriety, although that was not their intent. Judicial ethics demand not merely actual impartiality, but freedom from even the appearance of bias. A murmur circulated through the courthouse. Legal commentators looked at one another, acknowledging the cautious words of a judge anticipating damage control. Thus, in accordance with 28 U.S.C. paragraph 4 and 55, I am recusing myself from continuing proceedings in this case as of today. The gallery was filled with shocked chatter. Journalists hurried to rewrite their reports as the judge went on. In addition, Terenga interjected, speaking a little louder than his normal voice to be heard above the hubbub. I'm vacating the order of contempt against Congresswoman Crockett. The court recognized zealous advocacy, such as contesting judicial decision with pertinent precedent, is not only allowed but also required for our adversarial legal process. Crockett nodded cautiously, but did not change her professional composure. Her lawyers shared subtle glances of vindication. This case will be randomly reassigned to another judge in this district under standard procedure. Terenga went on. All prior orders in this case will be subject to reconsideration by the newly assigned judge. He turned to Crockett himself. His tone considerably changed from the angry dismissal he had exhibited previously. Congresswoman, although the court insists that some of your characterizations were needlessly inciting, your underlying concerns about procedural limitations on witnesses were not unfounded. The new judge will address those matters anew with clean eyes. This stunning concession elicited another ripple of murmurs around the courtroom. Deputy A.G. Reed was especially ill at ease, aware that the procedural benefits his side had enjoyed may now be turned around. Finally, Judge Terenga stated, I want to make a more general comment about the role of the judiciary. There was a reflective tone in his voice seldom heard from the bench. Our courts work optimally only when all the players have proper boundaries. Judges should be kept above even the appearance of undue influence. Lawyers should be able to forcefully attack decisions without disrespecting the institution. He stared at Crockett, and when either party fails in these obligations, our system has remedies. Today's hearings, while extraordinarily contentious, show that these checks and balances are still effective. With that philosophical aside, a far cry from his previous threats to jail a sitting congresswoman, Judge Terenga handed down his final ruling in the case. This court is now in recess awaiting reassignment. We are adjourned. As he stood to exit, something unprecedented occurred. Rather than immediately leaving through the door behind the bench, Judge Terenga approached Congresswoman Crockett's table. The courtroom watched in stunned silence as he extended his hand. Congresswoman, regardless of our legal disagreement, your dedication to the rule of law is evident, he said, just loudly enough for those nearby to hear. I regret that our proceedings reached such a contentious point. After a moment's hesitation, Crockett accepted the handshake, responding with equal professionalism. Thank you, Judge Terenga. Our judicial system's integrity concerns all of us, even when we are on opposite sides of contentious matters. It was a fleeting moment for only seconds, but the symbolism was strong. A federal judge admitting that his effort to jail an attorney for questioning him was in error, and the targeted attorney reacting with dignified professionalism instead of victory. As Judge Terenga left the courtroom for the last time in this matter, the gallery burst into action. Reporters scrambled to file reports about the dramatic reversal. Legal commentators argued the implications for judicial ethics and attorney advocacy rights. And in the midst of it all stood Congresswoman Jasmine Crockett, who had moved from near being escorted out in handcuffs to winning a full do-over of a critical voting rights case. Her lawyers got around her with congratulations, but Crockett was not interested in the personal win so much as the merit of the case. "This isn't about me or Judge Terenga," she said quietly. "It's about making certain that all eligible voters can exercise their constitutional rights without undue obstruction. We've eliminated one of the obstacles today, but our true work goes on." Beyond the courtroom, as television cameras masked, the case that had started as a technical challenge to voting berries had evolved into something much broader, a melodramatic display of power, responsibility, and the continuing relevancy of ethical constraints in America's justice system. The sun glared in the afternoon, sending deep shadows over the courthouse steps as Congresswoman Jasmine Crockett stepped out, flanked by her lawyers and members of the Voting Rights Coalition. A stand of microphones stretched before her with dozens of cameras and a throng of supporters who had arrived after news of the morning's sensational developments spread on social media. Instead of standing resplendent with triumph or vengeance, Crockett walked up to the microphones with the same restrained calmness that she had shown all morning in the courtroom showdown. Her opening words established the tone for the description of the day's events. "Today's hearing wasn't about some personal grudge between myself and Judge Terenga," she started, her voice firm and steady. "They were about something greater, the integrity of our justice system and the inalienable right of every American to have his or her voice heard at the ballot box." As cameras flashed and news reporters shouted questions, Crockett kept her eye on the larger picture and not on personal melodrama. "What transpired in that courtroom reflects both the test and the strength of our legal system," she went on. "When judges observe proper ethical boundaries, and when lawyers plead vigorously within professional codes of conduct, our process of adversary works as designed. When either side departs from those guidelines, there are corrective measures available to rein." A reporter shouted, "Congresswoman, how did it feel when the judge ordered you taken into custody?" Crockett smiled faintly. "I never for a moment doubted that truth would win. I was worried not about myself, but about my constituents, the voters whose very rights are on the line, and with each minute we spend debating courtroom theatrics, there's a minute we're not paying attention to the real question, which is that every eligible voter to vote without undue barrier." The reply shifted the debate from personality and back to substance, something Crockett had made a career of. At the same time, within the courthouse, the impact of what had transpired that morning was already percolating throughout the legal community. Court personnel spoke in whispers of Judge Terenga's rare recuse and the events that compelled it. Salts of the federal bar passed around speculations to next steps, both for the case and the judge himself. In just a few hours, legal blogs and news outlets carried in-depth analyses of the showdown. Constitutional analysts contributed to the boundaries of judicial contempt authority in the face of legitimate objections to impartiality. Judicial ethics commentators addressed the consequences of closed exchanges that Crockett had theatrically exposed. By evening, the news had spread beyond court circles to the national news. Cable shows featured segments with such headlines from handcuffs to vindicate how a congresswoman stood her ground and judicial ethics in the spotlight. The Terenga-Crockett showdown. Twitter exploded with support and backlash for both leaders. Hashtags sheer Crockett courage and judicial accountability trended in conjunction with respect the bench and judge targeted. The case had struck a chord in a divided country, forcing deeper questions about power, responsibility, and the rule of law. 3 days following the dramatic courtroom encounter, the U.S. Court's Administrative Office revealed that Judge Terenga had asked for an leave of absence until the Judicial Conduct Committee investigated the issue. The statement clarified that this move was voluntary and not a concession of wrongdoing. The case itself was remanded to Judge Elaine Rodriguez, a seasoned jurist renowned for her assiduous oversight of procedural equity. In her initial hearing, she authorized the plaintiff's request to recall the voter whose testimony had been restricted, indicating a noticeable restart of proceedings. Within a week after the face-off, Congresswoman Crockett was asked to lecture Harvard Law School's annual Judicial Ethics Conference. Her address, titled Advocacy and Accountability, Maintaining the Balance of Justice, was based on her experience, but did not attack Judge Terenga directly. "Our legal system operates optimally," she said to the gathering of judges, lawyers, and scholars, "when power is balanced by ethical limits. Judges have huge power in the courts, and they should. but it must be balanced by open impartiality and receptivity to proper advocacy. She went on, likewise, lawyers do not only have the right to represent their clients aggressively, even if that involves going up against, but that advocacy must still be based in law and fact, advance professional respect for the, if not always accord, with the person sitting on the bench. The address was universally acclaimed for its balanced and soon became mandatory reading in judicial classes across the country. Meanwhile, in Texas, the voting rights viewed before Judge Rodriguez, the formerly excluded Texas, was now all heard, placing on the record experience of voters who had encountered problems under the new constraint. The expert witnesses from both sides were tested thoroughly, building a fuller factual record. 2 months following Judge Terenga, the Judicial Conduct Committee made its report. Though they accepted that the contact with Secure Vote's CEO should have been made public, they determined that there was not enough evidence of existing bias. The committee suggested further ethics training, instead of formal action. Judge's long servicely untarnished record. Judge Terenga made a public apology for accepting the findings of the committee and admitting his lapse of judgment. Even the perception of impropriety taints public faith in our courts, he said. As a judge for 30 years, I fell short of the transparency our system demands. For that, I apologize not only to the litigants in this case, but to all who have faith in our courts for unbiased justice. He stated that after his return from leave, he would recuse himself from any cases regarding election law or voting rights, so that no issue of impartiality could exist. The longest-lasting effect, however, was 3 months later when Judge Rodriguez made her decision in the voting rights case. In a lengthy 87-page opinion, she invalidated central provisions of the law being challenged while validating others, rendering a complex decision both parties characterized as thoughtful, even when disagreeing with certain findings. The ruling directly referenced testimony that had originally been barred, observing that first-hand accounts of voters' experiences are critical to understanding the real-world consequences of electoral rules. When journalists questioned Congresswoman Crockett about her response and reaction to the split ruling, she replied in a manner that demonstrated the values she had fought for since the onset of the case. This ruling is evidence of what can be achieved when courts approach all the evidence and legal claims at issue. We didn't prevail on everything, but we got a good hearing, which is all that any advocate can reasonably hope for. The case ultimately made its way to the Fifth Circuit, where the panel of judges explicitly commended the exceptionally thorough record and balanced evaluation in Judge Rodriguez's decision. 1 year following the confrontation, Harvard Law Review featured a detailed examination of the case and its consequences under the title, When Advocacy Meets Authority: Lessons from Coalition for Voter Access versus Texas. The article considered how the case reflected both the tension and interdependence of zealous advocacy and judicial power. The last paragraph grasped the lasting lesson. What started out as a personality conflict finally reaffirmed a basic fact about our legal system. No actor, neither attorney nor judge, is beyond accountability. Judge Terenga's bid to incarcerate Congresswoman Crockett for questioning his impartiality failed not due to political interference or media arm twisting, but because our system has inherent correctives when power is abused. It was not personal vindication for Crockett alone, but also a reiteration that in the American courts, law and fact ultimately conquer position and authority. To law students, practicing lawyers, and judges nationwide, the case served as a vivid reminder that legitimacy of the legal system relies not on unchecked authority, but on ethical limits, procedural justice, and the willingness to resist when those values are at stake, no matter the personal cost. And as to Congresswoman Jasmine Crockett, she resumed legislative work with increased credibility as a stateswoman of principles and an upholder of constitutional standards. Asked in a later interview whether she was scared when it appeared she might go to prison for her advocacy, she responded in terms of the unflinching resolve that had converted a crisis into a milestone endorsement of judicial integrity. In Terenga, that instant I wasn't considering handcuffs or prison, I was considering my clients, the Constitution, and the integrity of a system I've sworn to defend. When you know you're on firm legal footing, fear yields to something stronger. The assurance that truth presented honest will ultimately trump. If you enjoyed this video about bravery against authority, Please subscribe and like our channel for more videos on Americans fighting for justice and constitutional value. Comment below what you think about this amazing standoff between a federal judge and a Congress who would not be silent. Tune in again next week for another inspiring tale.